Okay, I think we're all here. Mr. Wilson, you're up, sir. Are you going to reserve some rebuttal time?
Respectfully, yes. 5 minutes, Your Honor.
Okay, we're ready whenever you are.
Thank you. May it please the court, Matt Wilson on behalf of the appellant Jason Sanchez. This is a post-judgment modification action predominantly pertaining to alimony and child support with the fees component as well. I do want to take a moment to address the chronology, especially since we have some cross-pollination between the former appellate case number 1991 and the case here too. Issue number 7 and the case number 1991 was the issue now before this court. The trial court's determination of the former wife's entitlement to fees and costs. And at the time of that appeal was filed, the amount had not been determined. On September 20th of 2021, the trial court entered the order on the amount, as well as an order on contempt. Both of those said orders were subject to the October 13th, 2021 notice of appeal before this court. 1991 was per curiam affirmed on April 20th of 2022. And on April 25th of 2022, the trial court entered an order that encapsulated the September 20th, 2021 order as it pertained to the contempt issue. Thereafter, on June 16th of 2022, the parties here too filed a stipulation of dismissal as to moot, dismissing the issues raised in the September 20th, 2021 appeal pertaining to issue number 1 at that time, which was the order on contempt. That trial court order being Exhibit A to the stipulation, thus leaving the original aforementioned issue number 7 from the appellate case 1991 as the remaining matter in this particular issue 3208. I mention that because the record before us is not items since September 20th of 2021, other than the aforementioned April 25th, 2022 order, which does note a garnishment order which had a balloon accelerant option, which was reserved in the trial court September 20th, 21 order, and also references an equitable distribution payment, more on the latter that I'll discuss later. The issue of need and
Mr.
ability.
Wilson, can I ask you a question just early on?
Yes, sir.
Your opponent has raised the question of whether or not there is a transcript of the hearing in which fees were set. And yet there are recitations in the briefs to a transcript that appears to be from that hearing. Do we or do we not have that transcript?
We do, Your Honor. There was a motion for a supplement of the record of which this court entered an order, and I can give you the specific date. October 19th of 2022, the record and supplemental records from case 2D21 1991 are hereby docketed in case 2D21 3208. Excuse me. That included also the trial transcript.
Okay, so the
February 17th.
Transcript issue is not on the table.
I believe that particular issue is mooted by way of that supplemental order.
I thought that was the case. I just want to be sure because it's a little confusing the way it was briefed.
Understood.
Mr. Wilson,
Yes.
Mr. Wilson, just to clarify on the transcript, though, that transcript of the hearing is there, but is there a transcript of the court's oral pronouncement of its ruling on August 27th of 21?
As to the oral pronouncement itself, I do not believe there is.
Okay.
There was a transcript from the hearing itself, but I do not believe of the oral pronouncement.
Okay. That was the only one I could not find. I just wanted to make sure I was accurate on that. Thank you.
Thank you. The issue of need and ability pertaining to alimony was the crux of the appeal in 1991. The logic being if there was no need and no ability to pay alimony, then there was further no need and ability to pay the attorney's fees. And of course, as to alimony, the court respectfully disagreed and affirmed that award. That determination as to alimony further solidifies, however, that the appellant's ability to pay attorney's fees and costs was even further diminished for one of a litany of reasons that I'll set forth here shortly. The issue of affirmance of the alimony award aside, the starting point of the trial court's determination of need and ability and financial resources goes back simply to the difference between the trial court's April 9th, 2021 supplemental final judgment.
But Mr. Wilson, the court made that determination of alimony when it granted entitlement to fees. So what has changed other than we've affirmed the trial court's decision? I don't understand how that affects what we're dealing with now.
Certainly, Your Honor. In part, the significant issue here is then on June 4th of 2021, the trial court entered a second amended supplemental final judgment. And in April 9th of 2021, that version of the supplemental final judgment, the trial court made a determination that it is not appropriate to impute income to the former wife. Thereafter, and the court made other findings, including that the former husband's company runs on credit and currently had a debt of $1 million, only about $10,000 left on the line of credit, and that there is not sufficient retained earnings to distribute. And more importantly, it made a determination that it does not appear that the former husband's company is in the best financial situation right now. I mentioned that, and I'll segue to further answer your question. The court also found that the former husband does not have the ability to pay retroactive alimony. And to answer your question specifically, paragraph 29 of the April 9th, 2021 supplemental final judgment made that determination that the former wife has the need and the former husband has the ability to pay former husband's attorney's fees. Conversely, on June 4th of 2021, the trial court found that the former wife stated she has no objection to the court imputing $75,000 per year of gross income. Therefore, the court will impute $75,000 as to gross income to the former wife for purposes of alimony and child support. However, the trial court did not make the finding as it related to fees. So to answer the question is, the court previously made the determination of entitlement, then heard that we should impute income to $75,000 to the former wife, and transposed its original findings of entitlement simply into the second amended supplemental final judgment, which became paragraph 30. It was paragraph 29 preceding that. So we believe there was a significant change as it relates to the trial court's analysis as to how to make a determination of need and ability when the trial court made its initial determination of need and ability based upon the absence of imputation, and further finding that it was improper to impute income. And then in its second amended supplemental final judgment is when it added in the $75,000 in income. And we'll talk about the totality of the financial resources and the assessment of determining where the need and ability comes into play, fees being last in the chronology, if you will, as the resulting financial resources of the parties. And respectfully, we believe that the trial court simply transposing that it had previously made a determination of entitlement, absent the finding of the imputation that came subsequent, was essentially the linchpin that set in motion the fatal flaw, if you will, in terms of rehashing and reaffirming its need and ability had been found, and therefore the entitlement.
So, okay, so what you're saying then is that when the court imputed the additional income to the former wife, that the court should have recalculated at that point and reassess need and ability.
Yes, Your Honor. And part of that is on the basis that the court made that determination absent any income other than rental income and investment income to the former wife, and thereby inserting $75,000. Obviously that took, in addition to the $7,762 in alimony, it became a significant factor in terms of the distribution of the income, if you will, and the resulting financial situations of the parties. So yes. As briefed, we've indicated that there's no dispute, I believe, as the determination of entitlement is discretionary, but it is not an unfettered discretion. And as noted, I've hit on previously, as noted in Fenton v. Smith, 318 Southern 3rd, 1992, a 5th District Court of Appeals case. It's a critical factor for the trial court to consider the parties' resulting financial resources. Now, that case was a little bit distinguishable because it was a divorce, but it follows the same logic that we do the fees last after the court made the determination of modifying alimony, child support, and then of course issue number 3 was fees, where there was entitlement but a reservation as to the amount. Not to rehash the initial brief, the reply brief, or the record, but when viewing Florida Statute 6116 and its standard, it's a may, not a shall. And when we're considering the financial resources of both parties, the record here and the evidence did not support the trial court's blanket assertion that the former wife had a need and the former husband had the ability to pay attorney's fees and costs. And a bit, again, like the convoluted tapestry of the chronology, more importantly, the financial resources is equally a bit of a convoluted tapestry, but I'll note a few examples here. The trial court did not determine that the $4,417 payment of the former husband was not considered in the column of financial resources for the former wife. The equitable distribution interest was not considered by the trial court.
And
And-
what legal authority do you have that allows the court for consideration of awarding attorneys' fees and costs on need and ability to consider that equitable distribution as income?
In part, under 6116 itself, in terms of considering the financial resources, I believe in the appellate.
Any cases? Because don't the cases say the opposite, that the court should not consider the equitable distribution because of the fairness of putting everyone on the same playing field?
Well, yes, and certainly from the perspective of, you look at liquidity and non-liquidity and real property in terms of the accessibility, and the court is not requiring the former wife to use her alimony to satisfy her attorney's fees or to liquidate assets, especially if they have non-liquidity. But in terms of a general sense, and it's important to note, because not only did the court not factor the $4,417 payment to the former wife in its totality of the assessment of financial resources, it actually assigned it to the former husband as it relates to income. And so we're following the logic of the trial court to say that, well, if it shouldn't have been considered for the former husband, it shouldn't have been considered for the former wife.
Well,
but yet,
didn't the court do that because the business was actually paying the court found that although the former husband had $200,000 in salary, that the business was actually paying the equitable distribution payments, and therefore that was attributable to the husband as income. And I think it was even consistent on the husband's financial affidavit that his income was actually higher than the 200 salary.
And unfortunately that was an issue under the 1991 of which financial affidavit that the trial court considered. But to answer the court's question, yes, the court did factor it in and made that specific finding that the $4,417 was being paid by the company, but we still have the lacking of the fact that it was being turned right around and provided to the former wife. So we again, I think that gets to the central issue.
I don't know that the analysis is the same there, because the court was not looking at it as equitable distribution. It was looking at it as that it was income that was attributable to the husband, for the former husband, because it was being paid by the business. So he was getting the benefit of that as, I guess, as a distribution.
Certainly. And I think when we look at the trial court's findings as it relates to specifically that the trial court found that the former husband's business was not in the best financial situation right now. And again, I would concede that perhaps is not the focal point, and certainly not when we look at the resulting incomes of the parties post the totality of the financial resources of each party, and specifically as it relates to the income itself. And because the court had also made findings that the business had been drawn to the full extent of its line of credit and only had about $10,000 left. And some of, especially in the February 17, 2021 trial, a lot of that was argued as it related to the ability for the former husband to take distributions, of which the court also made consideration of factoring add backs into the former husband's income.
But the trial court also found that the former husband was paying off the debt of the business first before his legal obligations for child support and alimony. So,
which in part was kind of became circular logic to some extent, and became significant in many different rounds of the litigation, as well as for the former husband's ability to satisfy the distributions. He needed to satisfy the line of credits, and when they were maxed out, and as the trial court heard and did not make an express finding in the order itself, but did hear argument and testimony as it related to that most of the former husband's inventory, any retained earnings were not in existence. They were actually in the form of the inventory. So it was a bit of a circular logic in terms of the former husband had to satisfy those obligations before being in a position to ensure that he could make those payments as well.
Mr. Wilson, why don't you turn to the other issue here on the payment plan? I think
Sure.
your argument is that the trial court's order lacks the necessary findings to explain why the payment plan was entered by the court. And I noted in one of the hearings, and it may have been the August 25th hearing, that you made a comment, something to the effect that if the court awards this, the attorney's fees, that there would be some sort of payment plan or something to that effect. And I guess the question that I had, because that was, I think, the only thing that I've seen in the record that referred to a payment plan. Is there any, did either of the parties recommend to the court any number of months? Or did you reference that if the court was to award fees, that the court should consider a payment plan? I'm trying to figure out where in the record, because it just sort of pops up in a statement that you made at the hearing.
And I believe that
You're
was
well into your rebuttal time, sir, just so you know.
thank you. I believe that was the totality of the argument in its entirety, because I think the court was looking at ultimately that determination of the $80,000 in fees and made the concession that he being the former husband did not have the present ability to satisfy that in full. But I don't recall specifically if months or even dollar amounts were assigned or argued one way or the other. I think the argument I can safely say was the former wife was seeking the full contribution in full. And then if the court was ultimately going to determine that he did not have that present ability to pay it in full, that it would necessitate some form of a payment plan. But I don't recall duration or amount. And I certainly acknowledge that the appellee's brief talks usually that the findings are insufficient as it relates to the duration being too long, and that the 23 months was reasonable under the circumstance. We note this, and again, because there's again a significant post even this order's litigation in terms of stay orders and modifications of the payment plan. As noted, there was ultimately a garnishment, and the balloon payment came due and was accelerated. So the former husband was subjected to both the balloon accelerated full balance payment as well as the monthly payment, as noted in the trial court's order, which created a situation where the trial court made no findings as it related to if they became due in full, other than that they were due within 30 days, and how to satisfy the balloon payment. And ultimately, it's not an issue of whether or not the sufficiency of the findings created a scenario where it was too short or too long. There was no mechanism. And I say that in just briefly, in ignoring the $4,417 payment, the trial court is unequivocal, made a finding that the former wife had net income of $7,787. That's exclusive of the interest, and I'll exclude anything as it pertains to the equalizing payment to $4,417. And then when you add back the alimony, it's $7,672. That was a resulting net income to the former wife of approximately $14,000 or $15,000. Conversely, the former husband, the trial court made a finding of $20,501 net income. Again, for purposes of this exercise, noting that the $4,417 actually got transferred back out to the former wife. And in addition, the $7,672 in alimony payments was a resulting net income to the former husband of $8,412. And I say that because the trial court made a determination that the ability to pay the alimony was the $7,672 was the deficit that the former husband was listing as his own attorney's fees payment. And so that became the finding as to where his ability to pay the alimony came from, in conjunction with the court determining that there was the financial resources of the business were not great, coupled with the fact that the former husband did not have the ability to pay any retroactive alimony. We look at where that $3,500 would come from, and the fact that we believe the trial court committed the error by not factoring in the alimony payment and the resulting financial resources.
Mr. Wilson, you're at 18 and a half minutes, which means you would have a minute and a half of rebuttal time left, but you can keep going.
I'll wrap it up with that final statement, and that resulting net income, the trial court did not consider how that payment plan would affect what the court had already found to be a tedious ability on a monthly basis. And so for those reasons, we are respectfully requesting that this court reverse and remand with instructions to the trial court. Thank you.
Okay, you'll have 1 minute when you return. Okay.
Thank you.
Mr. Redder, did I say your name right?
Reader, Judge.
Reader, okay. Go ahead, sir. It's your time.
Good morning, and may it please the court. My name is Andrew Reader, and I represent the appellee former wife, Sean Veit. We start with the second amended supplemental final judgment entered June 4th, 2021. The 10-page judgment is thorough and includes detailed findings which confirm appellee's entitlement to attorney's fees and costs. The judgment attached.
Mr. Reader, let me ask you the question that Mr. Wilson was addressing as far as the need and ability that the trial court did not recalculate or consider the $75,000 in imputed income when it was calculating the need and ability.
I'm not sure what the basis for that is, Judge, considering the second amended supplemental final judgment, the June 4th judgment, specifically imputed income to wife. That's in paragraph 16 of the judgment. And in that same judgment is where the court found an entitlement to attorney's fees and costs, and that that appellee had a need and that former husband had the ability to pay. So considering that judgment includes the imputation of income, I don't believe that there's any basis or grounds for that argument. The
And
judgment correctly found appellee had a need for attorney's fees and costs, and that appellant had the ability to pay. Both parties agreed that the standard of review in this case is abuse of discretion. Appellant is unable to meet his burden to prove no reasonable judge would have entered this judgment. Appellee demonstrated her need and appellant's ability to pay, and appellee had a large monthly deficit even after the alimony award, and there is a
It
substantial
seems to me that his
disparity.
argument not is so much about discretion, it's about the failure to make the appropriate findings, which the law requires. So you want to address that part of it, not so much the discretionary part, but the absence of findings.
Yes, Judge. Well, there's findings throughout the judgment that this is a long-term marriage of 21 years and 9 months. For the majority of the marriage, the appellee was a homemaker and primary caretaker to the party's 2 children. And I know Mr. Wilson took issue with some of these findings. These are findings that the court made in the second amended final judgment. The judgment notes that for most of the marriage, appellee was an unpaid employee of the family business in addition to her homemaking duties, whereas the appellant took the entire salary for the family and he was the breadwinner CEO. The judgment makes specific findings that appellant earned significant income. In evidence is his financial affidavit dated February 9th, 2021, which was just before the final hearing, where he identified his income at $292,000 per year. There was additional evidence from the final hearing, which indicates an even higher income, including a loan application appellant signed 1 month before the start of the post-judgment proceeding, where he listed his annual income at $795,000. Also in evidence is once again the financial affidavit, where the appellant valued his interest in 2 companies at $3,396,000. He also identified $38,000 cash in personal bank accounts. There are numerous findings, Your Honor, in the judgment that substantiate the entitlement to attorney's fees and costs in this long-term marriage. One of the biggest issues is the fact that there is a substantial disparity in incomes, assets, and overall financial resources. On page 16 of the answer brief, we cite numerous cases in appellee's favor on this issue, starting with 2 cases from the 2nd District, Mount v. Mount and Lohman versus Lohman. There's another case cited on page 16, Baker v. Baker. In all 3 cases, the parties' estates were equally divided and the husband was ordered to pay the wife alimony. And in all 3 cases, the appellate court found the wife was entitled to attorney's fees and costs due to a substantial disparity in the party's income. From the case law, a straightforward rule emerges. A substantial disparity in incomes is a major factor supporting an entitlement to attorney's fees and costs. And in this case, there's no question whatsoever that appellant's current and historical income is significantly greater than appellee's.
Mr. Rader, to what extent should we look at the attorney fee award of $80,000 and determining whether or not that can be paid by the former husband here? Because that's an additional $80,000 of debt that's going to have to be paid over a period of time. Is that something we need to consider in the husband's income and expenses?
Well, the court needs to consider whether the trial court may abuse their discretion in finding that the appellant had the ability to pay. because there are specific findings both in the second amended supplemental final judgment, the June 4th judgment, as well as the September 20th, 2021 order that the appellant had the ability to pay. So at this stage of the case,
Is it the ability to pay the full $80,000, or is it the ability to pay the monthly payments that we need to be looking at?
the trial judge in this case specifically found, and I'm looking at the fee order, that in its paragraph T of the fee order, page 5 of 6, former wife's reasonable attorney's fees and costs are $80,470.37. The court then went on to find that former husband has the ability to pay the specific amount awarded in fees and costs. So the trial court made a finding.
But I think that finding also incorporates or is relying upon, and maybe I'm wrong, but correct me if I'm wrong, is the trial court relying on the tax refund of $42,000 that has yet to hit, and also relying on the cash out of the former husband's IRA of, I think it was, I don't know, 38,000 something, 28 or 38,000, something to that effect. Is that what the court was relying on to determine that the former husband had the present ability to pay?
Well, the court properly considered the appellant's overall financial resources, which isn't just his income, it's also his assets, and the fact that he was the sole owner of a profit generating business that generated hundreds of thousands of dollars of income every year. As Your Honor pointed out, on his financial affidavit shortly before the final hearing, the appellant listed $38,000 cash in personal bank accounts, and that's addition to his income, which based on his financial affidavit was almost $300,000 a year. But as I indicated earlier, there's even further evidence in the record that his income was substantially higher than that, including once again the loan application that's in evidence that he signed 1 month before the start of the post-judgment proceeding, where the appellant himself identified $795,000 as his annual income. And that wasn't just blustering on a loan application. The record evidence, including the 2017 and 2018 tax returns, indicated the same, a substantial amount of income every single year. Specifically, the 2018 return, he reported $795,000 of income, and the 2017 return, he reported $660,000 of income. So there is substantial evidence in the record of the appellant earning a very high income. We know that he valued his business at $3,396,000. He had $38,000 cash in his bank account, and overall, he has substantial financial resources.
What the on the other issue that is raised, as far as the trial court's order did not have the requisite findings to apply or institute a payment plan. The cases Perez, Lohman, Rogers, I'll talk about that the court is required to make findings. Why should we not follow those cases in this case?
Well, all of those cases are distinguishable, Your Honor, because as Mr. Wilson concedes, they're the exact opposite scenario of our case. In all three of those cases, payment schedules were reversed for providing the obligor with too much time to pay the fee award. The order in this case contains detailed findings that former husband has the ability to pay the amount awarded. Rather than providing the appellant 2 years to pay, once the court found entitlement, once the court found need, and once the court found ability to pay, the trial court could have simply ordered the appellant to pay all appellee's reasonable attorney's fees and costs immediately. As the court explained in Wright v. Wright, the second district, payment schedules are really an exception to the rule that fees should be paid immediately, because lengthy payment schedules discourage competent attorneys from representing clients in dissolution of marriage cases, thereby defeating the purpose of the statute. In this case, Your Honor, there's also another distinguishing fact from the cases cited in the briefs by Mr. Wilson. In this case, there's an acceleration clause requiring the appellant to pay the entire outstanding balance if he is more than 30 days late in making a monthly payment. If appellant takes issue with the 23-month payment schedule, he can simply miss a payment and the entire amount becomes due, which is what happened here, rendering the payment schedule moot. And the order contains a specific factual finding that appellant has the ability to pay the exact amount ordered, a conclusion that is well supported by evidence in the record, including appellant's substantial income, his high earning capacity, his sole ownership of the income generating business, his liquid assets, and the disparity in the parties' overall financial resources. So those cases are not controlling, Your Honor, and they're distinguishable, and they're factually an opposite to the case at hand. We also point out in the brief that it's not only a party's income that the court should consider, but the court should also consider a party's future earning capacity. And there's several cases cited on page 17 of the brief that highlights the importance of earning capacity. On another issue, and Judge Smith, you mentioned this during Mr. Wilson's argument, appellant is essentially arguing that the appellee should pay all 100% of her own attorney's fees and costs from her alimony or her equitable distribution. But this fails to consider the Knackers decision, which found that an award of attorney's fees and costs is proper to avoid an inequitable diminution of the fiscal sums granted. Significantly, and this is a big part of this case, most of the appellee's equitable distribution is illiquid or in the form of an unpaid 15-year equalizing payment. In the Pfeiffer case cited on page 19 of the answer brief, the 4th DCA reversed the denial of attorney's fees and rejected husband's assertion that wife should pay the fees out of other awards made to her because the purpose of the other awards, including alimony, would be substantially undermined if they were required to be used for attorney's fees and costs. Page 20 of the answer brief cites the Conlon case, the Fleming case, and the Alpha cases to illustrate this point with regard to equitable distribution. In all three cases, the court held it would be inequitable to require the needy spouse to pay their attorney's fees from their share of the equitable distribution. And this brings us to another major point. Like the Fleming and Alpha cases, a large portion of appellee's equitable distribution consisted of a $639,000 equalizing payment paid in installments over 180 months or 15 years. At the time of the final hearing, and the appellant reflected this on his financial affidavit, the outstanding balance of the equalizing payment owed to appellee was $605,000. In other words, as of the final hearing, appellee had not received a substantial portion of her share of the marital estate. Appellant's obligation to pay the equalizing payment over the next 15 years provides little source for the appellee to pay her attorney today. Consistent with these principles of law and the record evidence, the court did not abuse its discretion in finding appellee is entitled to her reasonable attorney's fees and costs. In closing, we end at the same place where we began. The appellant failed to clear the high bar of proving an abuse of discretion. The record is replete with evidence that confirms and supports the court's entitlement finding and generous 23-month payment schedule. Appellee established her need for fees and costs, and the appellant has the ability to pay as noted in the trial court's judgment and fee order. The judgment and order should be affirmed. Thank you.
Thank you. Mr. Wilson, you have 1 minute, sir.
Sorry, it would help if I unmuted myself very briefly at all. First and foremost, as it relates to the Uniform Residential Loan application, the trial court did not consider that. It did hear testimony and evidence as it related to the numbers being used from 2017 and 2018, and wherein it was undisputed that I think the exact quote of the testimony trial transcript, page 1794, was that 2017 and 2018 were banner years. And more to the point is that the trial court did not consider that in its assessment of calculating the income of the former husband in February of 2021. Specifically in response, it was paragraph 14 of the second amended supplemental final judgment I think it was misquoted as paragraph 16, an easy confusion, but the specific line that the trial court found is related to the imputation of income. Therefore, the court will impute 75,000 as gross income to the former wife for purposes of alimony and child support. The court did not make a
You're out of
finding,
time, sir. Sorry.
did not make a finding as to fees. And with that, we thank you for the court's time.
Okay, well, thank you both. I appreciate it very much. You all did a nice job in your briefs and your arguments.